Welcome back to the deep dive. Today we are performing, well, a kind of legal autopsy and maybe even a resurrection.
Sounds intriguing.
It is. Our mission is to understand one of the stranger creatures in contract law, the zombie debt.
Ah, yes, the living debt of obligations.
Exactly. These are debts that are legally dead because the statute of limitations clock ran out, but under certain conditions a debtor can accidentally or maybe intentionally bring them back to life.
It's a really fascinating tension in the law, because normally the statute of limitations, the SOL, it provides finality, closure.
Right. If you wait too long, the court just says, nope, too late.
Exactly. But when a debtor makes a new promise to pay that old debt, the law often recognizes, well, the underlying moral obligation that still exists.
Like a legal ghost that won't quite disappear.
Something like that. So to analyze this resurrection spell, we really have to look at three main doctrines.
Okay, lay them out for us.
First, the SOL itself in New York. That's usually 6 years for contracts under CPLR Section 213.
6 years. Got it.
Second, the basic rules of contract consideration. What makes a promise legally binding.
Okay.
And third, the specific exception that allows this revival. That's found in the General Obligations Law, or GOL, Section 17101. That's our key statute here.
All right, let's dig into that. Starting with the basic barrier. If I loan someone money, standard promissory note, CPLR 213 gives me 6 years.
Correct.
If I miss that window, I'm normally barred. Right. So what's the fundamental legal loophole, the sort of crack in the door that GOL 17101 uses to get around this?
Well, that loophole really centers on consideration, or maybe a lack of new consideration in the traditional sense.
How so?
Typically, a new contract needs new consideration, a fresh exchange of value, something new given or promised.
Right, quid pro quo.
Exactly.
Yeah.
But GOL 17101 creates an exception. It basically says that the moral obligation arising from the original, now time-barred debt, that past consideration, is actually sufficient legal backing to make a new promise to pay enforceable.
Huh. So the old debt, the past consideration is enough.
It is, provided that new promise is documented in a very specific way.
Ah, there's the catch. So the law is saying, okay, we know you owe the money, morally speaking, and your conscience is enough reason to make a new deal. But that new deal, it can't just be a verbal handshake over coffee, can it?
Absolutely not. No way. The General Obligations Law is extremely strict on this point. It codifies the old common law idea, but it demands proof, hard proof.
Which is?
GOL Section 17101 requires a writing signed by the party to be charged, that's the debtor, to take an action out of the operation of the provisions of limitations of time.
A signed writing. That seems, well, incredibly specific.
Yeah.
And potentially harsh. Like if I accidentally scribble, yeah, I still owe you that cash on a napkin and sign it 10 years after the debt supposedly died, they can come after me.
Potentially, yes. That signed acknowledgement could be enough, which is precisely why we need to break down this rule into its testable elements. It's not quite that simple.
Okay, good. Let's do that. What are the essential parts?
You're right to focus on the elements because the law is very demanding here. For a debt revival action to actually succeed, we have to satisfy three distinct criteria.
Element 1.
First, there must be either a new promise to pay the debt or an acknowledgement of the debt, so one or the other.
Okay. Promise or acknowledgement.
Second, and this is crucial, that promise or acknowledgement has to be made in such a way as to imply a clear, unambiguous intention to actually pay it. Just admitting the debt existed might not be enough.
Ah, the intent matters. Okay. And third?
Third, this promise or acknowledgement absolutely, positively must be in a writing signed by the debtor, the person they're trying to charge with the debt. No writing, no signature, no revival, period.
Okay, that's our essential checklist. 1, promise or acknowledgement. 2, implies intent to pay. 3, signed writing. Let's test this. How resilient is this rule when someone tries to game the system? Let's look at anonymous v. anonymous. Sounds like a messy one.
It involved a domestic dispute, which always adds layers. And yes, there was a clear attempt at manipulation. The appellate court really had to cut through some clever dating tricks.
All right, let's analyze anonymous v. anonymous. First, give us the legally dispositive facts. What happened here?
Okay, so this case involves a wife suing her husband. She sued him based on 8 separate promissory notes. The total was pretty substantial, over $116,000.
Wow. Okay.
The key facts really revolved around timing. The original debts, the money loaned, had built up over many, many years, possibly stretching way back into the 1960s.
So likely time barred by the 70s.
Exactly. But then, critically, The 8 promissory notes themselves. They were physically signed and handed over by the husband on a specific date, July 9, 1975.
Okay, 1975. That's important.
Very. Because the husband intentionally put much older dates on them, he antedated them, made them look like they were signed back in 1961, 1967, 1968, and 1969.
Trying to make them look expired right from the start. Clever or sneaky.
Precisely. So when the wife finally sued in December 1980, his argument was simple. Look at the dates on the notes. They're from the 60s. The 6-year clock ran out long ago.
Got it. So, given that deliberate date manipulation, what was the core legal issue the appellate court had to untangle?
The precise legal question was this. Did the husband's act of physically signing and delivering those promissory notes on July 9, 1975, count as a sufficient new promise under the law? A promise that could revive the underlying, much older debts and reset the statute of limitations clock. And crucially, could it do that despite the fact the notes were deliberately backdated to make them look time-barred?
Right. Does the real execution date matter more than the fake date written down?
Yeah.
Okay. What rule of law did the court use to decide this? State the full rule and break down its elements again for us.
Sure. The court applied the rule we just hammered out, General Obligations Law, Section 17101. This statute allows a debt, even one barred by the statute of limitations, to be brought back to life, revived by a new written promise.
And the elements?
Right, the 3 key elements again. First, you need that new promise or acknowledgement of the debt. Second, it has to clearly imply an intention to pay. And third, it absolutely must be in a writing signed by the debtor.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step, just like you would on an exam. How did the court apply the first element, the requirement of a new promise or acknowledgement? Did signing those notes count?
Yes, it did. The court looked at the context. The wife testified she specifically demanded IOUs, these notes, covering loans made over many, many years before she'd even consider advancing him any more money.
So as a condition for future help.
Exactly. So by actually complying with that demand on July 9, 1975, by physically creating, signing, and delivering those 8 notes, the court found he clearly and explicitly made a new promise to pay. The act of executing the instruments on that specific date was the new promise. Element 1. Satisfied.
Understood. Now, what about the second element, the requirement that the acknowledgement imply an intention to pay, and also the third element, the signed writing? How did the promissory notes themselves address those points?
Well, those two were actually pretty straightforward in this case. The third element, the signed writing required by GOL 17101, was obviously met by the 8 promissory notes themselves. They were written documents signed by the defendant husband on July 9, 1975. Check.
Okay, that's clear. And the intent?
For the second element, the intention to pay, the court found it was inherent in the nature of the documents. These weren't casual IOUs scribbled on napkins. They were formal promissory notes.
Right, the title itself says promise to pay.
Exactly. The court reasoned you don't formally execute and deliver documents titled promissory note for over $116,000 without unambiguously implying an intention to pay the sums listed. So element 2 was also satisfied by the nature and execution of the notes themselves.
Okay, so the notes themselves hit all 3 elements based on the act of signing them in 1975. But here's where the policy comes in, right? The husband deliberately tried to use the fake dates, the annotated dates on the face of the notes to get out of it. What did the court say about that intentional manipulation?
The court was, well, let's just say deeply unimpressed. They didn't just dismiss the argument. They made a strong policy statement about it.
What did they say?
They explicitly call the annotating an exploitation of the confidential relationship between husband and wife. Strong words.
Definitely.
Exploitation. And based on that, the court flatly refused to honor the dates written on the notes. They said they would decline to permit defendant to benefit from his own manipulation, especially within that spousal relationship. So the policy was clear. Equity demanded they look at the real date of the promise.
So the principle is the law focuses on the date of execution when the new promise was actually made, not some fraudulent date somebody slapped on the paper.
Precisely. Especially when there's evidence of intent to deceive or exploit a relationship. The actual moment of the new commitment is what restarts the clock.
That's a really critical point, especially for anyone drafting documents. Execution date trumps manipulated face dates. Okay, so after analyzing all the elements and factoring in that the true execution date was July 9, 1975, what was the appellate division's final conclusion in the case?
The appellate division reversed the lower court's decision, which had initially dismissed the wife's claim based on the face dates. They reinstated her motion for judgment and granted it.
So she got the money.
Yes. Judgment for the full amount, the $116,177 plus interest. And crucially, the court held that the statute of limitations began to run anew. The 6-year clock restarted from the date the notes were actually executed, which was July 9, 1975.
Which meant her lawsuit in December 1980 was well within the time frame.
Correct. It was timely. The debt was successfully resurrected.
That's a perfect illustration of how GOL 17101 works, especially when equity steps in to prevent abuse. But let's push on that nuance in the second element, the intention to pay. You said just acknowledging the debt might not be enough. Let's test that.
Okay.
Imagine a debt is, say, 10 years old, totally expired under the SOL. The debtor sends you a signed letter. It says, and I quote, "Hey, I definitely remember that $10,000 I borrowed from you back in college. Yeah, I owe you that. But listen, since you insulted my favorite hat last week, you are absolutely never getting a single penny back from me. Forget it." Signed, debtor.
Okay. Interesting hypo.
That's a signed writing. It acknowledges the debt's existence. Does that revive the obligation under GOL 17101?
No, that debt is not revived. Still dead.
Why not? It hits element 1, acknowledgement, and element 3, signed writing.
Because it spectacularly fails element 2. That scenario perfectly highlights the difference between merely admitting a debt existed and making an acknowledgement that implies a genuine willingness or intention to actually pay it.
The intention part again.
Exactly. Remember, the rule says the acknowledgement must be made in such a way as to imply an intention to pay it. A clear, explicit refusal to pay "you're never getting a penny" completely negates any implication of intent.
Even though he admitted owing it right before.
Yes. The overall communication clearly signals, "I admit I owed it, but I absolutely will not pay it now." That breaks the required implication. It kills the resurrection spell instantly. No intent, no revival.
Okay, that really clarifies the high bar for that second element. It's not just about signing something that mentions the debt. It requires a renewed commitment, or at least nothing that actively refutes that commitment. Got it. Okay, let's synthesize all this. Let's turn this analysis into an actionable framework for the listeners. If someone is facing a debt revival issue, maybe on a law school exam, or maybe trying to collect on an old account, what's the mandatory analytical checklist they should run through based on GOL 17101 and the case law?
Okay, we can definitely boil this down into a step-by-step diagnostic checklist. Think of it as your issue spotting tool for zombie debts. 4 steps.
Yes.
Step 1, primary bar check. First things first, figure out the original statute of limitations period for the debt type. Is it 6 years for a contract note under CPLR 213 or something else? Then determine if the original debt is actually prima facie barred. Did the clock run out based on the original due date? If yes, then you might have a revival issue, so proceed. If no, then you just have a regular timely collection case.
Okay, check if the SOL has actually run first. Makes sense. Step 2.
Step 2, the new promise trigger the writing. Now, look for the potential revival document. Is there a signed written document that was executed after the original debt became due and ideally after the SOL ran out? Remember GLL 17101, it must be a signed writing from the debtor. No signed writing, game over for revival. Stop here.
Crucial. Must be written, must be signed by the debtor. Got it. Step 3.
Step 3, intent analysis. This is where you scrutinize the content of that writing. Does it contain language that constitutes a clear new promise to pay? Or, if it's just an acknowledgement, does that acknowledgement clearly and unambiguously imply an intention to pay? This is where you apply the logic from our hat insult hypothetical. A mere admission of the debt's past existence isn't enough. A conditional promise coupled with a refusal isn't enough. You need that implied willingness to pay.
Analyze the words carefully for intent. Okay.
Yeah.
And the final step.
Step 4, date reset. If, and only if, you've satisfied. Step 3, meaning you have a signed writing expressing a new promise or an acknowledgement implying intent to pay, then the old debt is revived. The statute of limitations starts running all over again. And critically, the new SOL clock starts from the date the signed writing was actually executed. That's the date the new promise was effectively made. Ignore any funny business with annotated dates on the document itself, like an anonymous. The execution date is key.
Perfect. That 4-step framework. Check the bar, find the writing, analyze intent, reset the date based on execution. That really lays out the analytical path clearly. So the big takeaway here seems to be that past consideration, the original debt, can be enough to support a new promise.
Right. It's a recognized exception to the usual consideration rules.
But only if that new promise is properly documented in a signed writing and carries that genuine signal of intent to repay. And, as Anonymous showed us, courts aren't afraid to step in and prioritize the reality of when that promise was made, especially if someone's trying to play games with dates.
Exactly. The policy against allowing someone to benefit from their own manipulation, particularly within a confidential relationship, was very strong there, which actually leads to a final thought.
Oh, go on.
Well, we saw the court in Anonymous essentially use equitable principles, this idea of preventing fraud in a confidential relationship, to disregard the annotated date on the contract and enforce the GOL 17101 revival based on the execution date.
Yeah, they prioritize fairness over the literal text regarding the date.
Right, so here's a question for you, the listener, to mull over. Given the court's willingness to bend the interpretation of the timing element based on policy and equity, could a similar equitable argument ever overcome the seemingly absolute requirement of a signed writing under GOL 17101?
Hmm. You mean, what if the new promise was only made orally, perhaps recorded, but the debtor's fraud in later denying it was just as blatant or exploitative as the husband's anti-dating?
Precisely. We know the statute says signed writing, black and white. But we also saw policy concerns about fraud override the written date. Could extreme fraud or reliance, perhaps, maybe, create an argument to sidestep the writing requirement itself in a truly egregious case? The statute seems absolute, but, well, that's something for you to explore on your own.